Said, please give a warm welcome to Kathryn Tucker.
Thank you so much. Good morning. So how many of you have been Compassion and Choices members since even before the merger of those two entities? Okay, lots of long-timers. Okay, well, I was just going to say a little bit by way of background about Compassion and Choices. We are a national entity, so we advocate across all 50 states for improved end-of-life care and expanding choice at the end of life. And we have a lot of different things that we engage to push that envelope. So some of the things I'll be talking about, and really the idea of my talk today is just to bring you kind of up to speed on the different advocacy projects that we are engaged with now at Compassion and Choices, and they are fairly diverse and I think really exciting. So hopefully we'll have a good discussion about them. So, you know, one of the things that we know from our work at Compassion and Choices is that patients really don't know about their end-of-life care options. You know, so one of the things that we're very interested in is making sure that patients and families who are approaching death due to terminal illness have comprehensive counseling about a full range of end-of-life choices. So we think that a fully informed patient is a more empowered patient, and that it should be standard that with a terminal diagnosis, there's the opportunity for the patient to get comprehensive counseling from their healthcare provider about a full range of choices. And that might include any of these things and all of these things: hospice care, the right of the patient to refuse or direct the withdrawal of any life-prolonging intervention, whether that's a feeding tube, a ventilator, medication, a heart device. Any of those things can either be refused on the front end, or if they had been accepted, they can be withdrawn with appropriate palliative and comfort care so that that withdrawal is not frightening or painful. That's a right that patients have in all 50 states in the United States, and patients should know about that. There is a right to choose to stop taking food and fluid. That has its own acronym in the medical literature, wAID. It's well accepted in medicine, it's accepted in law, and yet you often will not be told about it. If you choose wAID, you should be supported in that choice. So you should have really good palliative care while you are in your fast. And that's just part of standard of care. We have a campaign going on at Compassion and Choices right now, and if you are regular readers of our website, raise your hand if you've heard about the Rudolph case. So, you know, a case in this domain came to our attention recently, and we are embarked on a campaign to bring it to the attention of the whole country because it's such an opportunity for education around wAID. And what happened in the Rudolph case is that Dorothy and Armand Rudolph, who were married for 70 years and were in their 90s, they were living in an assisted living facility in New Mexico, and they decided to, both of them, to wAID. And they had the support of their children, who their children were 65 or so, and lived out of state. The children knew about this and were supportive. The parents were in counseling with Compassion and Choices, so they understood the process and felt certain that was their choice. And when they told their assisted living facility, the assisted living facility called 911 and did a full suicide intervention with the police and fire emergency response, and they evicted the Rudolphs at age 90 and 92. So to be evicted at that age when you're that close to death is, of course, a really traumatic thing. The children flew in from out of state and went on vacation rental by owner and found a rental home and moved the parents to the rental home and stayed with them while they fasted, and they died within 12 hours of each other. The son, Neil Rudolph, was so outraged at what happened to his parents that he's now speaking out publicly at conferences like this and meetings all over the country where he's telling that story, because that's very wrong, very wrong. We have written a rider, and maybe you're distributing that, which if anyone is thinking of entering an assisted living facility, we offer this rider, or it's an addendum to the assisted living contract, where we really suggest some ways to protect yourself from that kind of treatment. So that's just a little side story. It's, if you go on our website and you look for VSED, you'll see the whole story about the Rudolphs. It's been written about now very widely in media all across the country. One of the things I think Compassion and Choices does nicely is we bring these stories into the public eye through a really good communications program. So we believe from our data that 50 million people have now read about the Rudolph case. So hopefully that's a good education, and we're just embarking on that education. In addition to VSED, palliative sedation, this is a choice that you'll almost never hear about. It is a choice that is accepted in both law and medicine. This is for patients who have the kind of pain and suffering associated with their dying process that is not relieved with conventional treatment. So all kinds of opportunities for good pain and symptom management should be explored. Often they're effective. For a fraction of patients, they're not effective. For that fraction, palliative sedation, which is also called terminal sedation or sedation to unconsciousness, that's another choice. You very rarely will be told about that choice. It's a hidden choice. We think that fact that it's so hidden is not right. And so we have a case in litigation now in California that focuses on that, on the duty of the provider to tell the patient about that option. And then also finally, some patients will want to have medications that they can self-administer to bring about a peaceful death. We refer to that as aid in dying. A big part of our work is around encouraging use of that term, because the opponents of that choice like to refer to it as suicide or assisted suicide, which is a value-laden, inaccurate term. So we're often encouraging our membership to watch news articles, and if you see the use of the term suicide or assisted suicide to refer to the choice of a dying patient for a peaceful death, we love it if you write letters to your editor and speak out at cocktail parties or whatever your circle of friends is to say the choice of a dying patient for a peaceful death is no kind of suicide. That's part of our work too. So we know patients don't know about, but we know from a lot of studies that knowledge is comforting. And this is just one of these studies that finds that. It reduces anxiety, depression, and worry when patients can have open, candid conversations about end-of-life choices. So we know that that is the data. And we know that patients who are empowered with information can make a wider and perhaps a better choice for themselves. So this is also reflected in a whole range of studies. So we support and promote policies that inform patients about all of their choices. So for example, we do work in legislatures around the country. We went into the California legislature with a bill called the Right to Know End-of-Life Options Act. That was passed into law in California in 2008, and it just it provides that when a terminal diagnosis is made, the provider, on the patient's request, shall provide comprehensive counseling about end-of-life options. After we had that bill moved in the California legislature, we were working with our New York chapter on a similar sort of bill, and we tweaked it a little bit, and we actually like the New York bill a little bit better, because as you notice here, it says the healthcare provider upon the patient's request. Well, not all patients will know to ask. So what we did, we like to think we learn as we go. In the New York bill, the provider is to offer the counseling. So it's a slightly improved version, and we are working with chapters and legislatures around the country to have similar bills enacted, and we're also working with the National Uniform Law Commission, because of course in all 50 states patients need information, and this is an entity that recommends the adoption of model legislation. How many people here are lawyers or were? Model legislation that other states can adopt. And so we're hoping that we'll have a model bill adopted at the National Law Commission. We also do a lot of work around strengthening laws and policies that hold providers accountable when they don't tell patients about choices. So for example, this first one, the Hargett case, if you're a regular visitor to our website, you know the Hargett case. If you haven't been there yet, you can check it out. This is a sad story of a woman, a young woman. She was 43 years old, and she was dying of pancreatic cancer, which is known to be very painful with a lot of symptoms. How many clinicians are here? Okay, known to be painful. And she entered hospice care. And hospice is supposed to be sort of the gold standard for aggressive pain and symptom management. And even though she was in hospice for 3 weeks before her death, almost every day during her hospice enrollment, her pain levels, which were being recorded, which is good because now it's standard to assess and chart pain levels. That's a modern thing, and that should happen, and it's good that it happened. The bad thing here is almost every day, her pain levels were between 6 and 10. Well, 10 is the worst imaginable. So you're really hoping that once you're enrolled in hospice care, you're going to bring the pain under control to below 3. Well, she was never brought, her pain was never brought under control. Now, so she probably was in that category of patients that I referred to earlier who have pain and symptoms that aren't managed with conventional therapy. She's the kind of patient who should have been told about palliative sedation. She never was. No one mentioned it to her. And so we're representing her survivors in a lawsuit filed in California that's the first in the nation to take up the question, if a provider fails to tell a patient about an important end-of-life option, is that something the provider can be held accountable for? So you can watch that case. It moves like a glacier, very slowly, but you can watch it as it unfolds. What we hope is that we will have success in that case in establishing the principle that failure to inform a patient about a choice is outside standard of care, not acceptable. And, you know, same thing with VSED, and we have another case we're looking at that we may be about to file also in California. But if you hear of cases, by the way, we're always interested. If you know of someone who's not having their needs met or who had a bad death or who had their wishes obstructed, you can bring those cases to our attention, because one of the things we do is look for cases that offer that opportunity to do education around the problem. So for example, we're looking at a case now in California where the patient had brain cancer, had a full ethics consultation about what the end-of-life wishes were. That's good, that's supposed to happen. And the wishes were reduced into what's called a POLST in California. Here, is it a POLST or a MOLST?
Most.
Okay, or a MOST. So these are a relatively new instrument for end-of-life care planning where the patient's wishes are explored and decided upon, and then those wishes are reduced or translated into a physician's order, because a physician's order is sort of the most powerful tool in the world of medical delivery. So a physician writes the order that reflects the patient's wishes. Well, this patient said, do not resuscitate, do not intubate. And that was written into a POLST, which here would be a MOST. 3 months later, there's an emergency. The patient arrives in the emergency department. And despite the existence of the POLST, signed, executed, T's crossed, I's dotted, the patient was intubated. This is very wrong. So we're looking at bringing that as a case, and I think it will be the first to bring forth a civil lawsuit about violating a patient's wishes as reflected in that kind of advance directive. So we do that kind of work. We do. Okay, I talked about Hargett. I don't need to say more about that. On the inadequate end-of-life care, I mean, we have been involved and we still are involved, but it seems less sort of cutting edge since we've done a lot of work in that area. If a patient doesn't get good pain and symptom management, we do bring those cases forward. And we were the first to bring forward, some of you may have heard of the Bergman case, show of hands if you know about that case. Bergman in California. This was a case where a 85-year-old man was dying of lung cancer. He was in a hospital. His pain levels were charted, and they were very high. They were between 7 and 10 during his 5 days in the hospital, and he was discharged at a level of 10, which is a crisis. So we did take a lawsuit against that physician that went to a jury verdict where the jury said that's not acceptable, and we won a big verdict for the family. And it brought a lot of attention to the duty of physicians to treat pain attentively and aggressively. And since then, we have heard that that case is now taught in medical schools and at medical conferences all over the country to bring attention to that. So we do bring those cases as well. I think I mentioned to you palliative sedation. You know, one of the reasons why I have this slide is we are seeing that there is acceptance of this intervention in the medical and palliative care field. This is the statement from the National Hospice and Palliative Care Organization, which is sort of the leading professional society for palliative care providers. So it's just now quite accepted when you see these practice guidelines. It's no longer permissible for providers to say, I didn't know about it. It's not a legitimate choice. It's so now embraced in the literature. And I think, yeah, I've told you about Hargett. Okay, so we do work in the arena of expanding choice to include aid in dying. 70% of Americans support this choice. We've done a lot of work in recent years in going into large national medical and health policy organizations. You may know some of these, and encouraging them to adopt policy that supports aid in dying. Because we believe that when there is that kind of support in the medical professional and health policy field, that kind of advances the issue. So we have gone to each of these organizations, introduced policy, and had very progressive policy adopted by these organizations. You can go to any of their websites and read the policies, and that's an important part of our advocacy work. And I think, you know, the great thing is that finally, I've been working in this field for 20 years. We are seeing change in a positive direction. So as you know, of course, Oregon adopted its law in 1994. The Supreme Court cases that invited the states to grapple with this issue were decided in 1997. The Oregon law started to be implemented in 1998, so we now have 13 years of implementation in Oregon. I'm not going to spend a lot of time talking about that because I've done that, I think, here before, and you probably are familiar with it. But I think the success of the Oregon model did very much influence the campaign in Washington in 2008, which was successful in the enactment of a virtually identical law. So now Washington joins Oregon as having a statutory framework under which patients can ask and physicians can provide aid in dying. So Oregon and Washington represent a category of states that have decided to permit aid in dying through statutory enactment. Now remember, those statutes were enacted through the initiative process, not through legislators voting, because it's still such a hot button issue for legislators. We have never yet seen a state legislature adopt legislation to permit aid in dying, but we have seen the voters do it twice. We had an interesting case in Montana. Who's been following the Baxter case? Show of hands. Okay, a couple of you, great. Well, so that was a case that we brought in Montana a number of years ago, where we had both constitutional claims and a statutory claim that citizens of Montana had the right to choose aid in dying. That case went up through the Montana courts, and the lower court said the Montana Constitution protects this choice. Now, lawyers always love constitutional rulings because they're so sexy and exciting. The Supreme Court in Montana said, no, 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 we're not going to go there. Courts don't decide constitutional issues if there is a statutory basis. And so the Supreme Court said, we don't need to reach the constitutional issue because we have this nice statutory basis. So they did a statutory ruling. The interesting thing about that is, because it was a statutory rather than constitutional ruling, the legislature could come in and legislate to nullify the court ruling. So it was so interesting in Montana. We weren't expecting the statutory ruling, but we got it, surprise. A great thing, really, for us in Montana is that legislature only comes in every 2 years. So we got our ruling at the end of 2009, I want to say. Is that right? I think so. And then we had a full year before the legislature came back to work. So in that year, Compassion and Choices worked really hard to educate the community, which, by the way, in Montana is a huge challenge, because how many people are from Montana here? Anyone from Montana? Very rural, very spread out. So we had staff and grassroots volunteers going around the state to meetings like this where there might be 6 people or 7 people or 9 people, because the population is scattered and small. But we did a great job, and all those meetings ended up really raising the consciousness among Montanans about this right that the court had recognized, so that when the legislature came back a year later, what do you think happened? Someone came in with a bill to say nullify the court ruling. Hinkle was the legislator's name. The Hinkle bill said we will make a crime of aid in dying in Montana. Well, the legislature considered that and did not adopt it. And that failure to adopt the prohibition we consider a great victory. And it was the product of a lot of education and work. And the great thing about that is I think we learned the lesson, and this is a key lesson, and that is defeating a prohibition is much easier than enacting a permission. Little lesson there. Are any of you legislators in your former lives? Well, it's so interesting because you might not think that just shifting the burden that much would change the game, but it does. Defeating a prohibition easier than enacting a permission. So we learned that in Montana, and we will use that lesson in other places. So the effort to ban aid in dying in Montana failed this year, and that was a big deal. Baxter was the name of the case. The significance of it, this is exactly what I just said. And so we will look for ways to take that lesson and apply it elsewhere. Now, here is where we're on the cutting edge of a new way of thinking about aid in dying at Compassion and Choices. And so, you know, Oregon and Washington were statutory enactments of a permission. Montana is a court decision that establishes a right. Statutes and court decisions are not the way most medicine is practiced, right? Very few medical procedures do doctors look in a statute book. Very few times do they open a court decision like Baxter. Most medicine is delivered by what's called either best practices or standard of care. And what that means is that the clinicians who practice in a particular area develop the treatment that is appropriate. And we think at Compassion and Choices that it is time for aid in dying to be governed by best practices standard of care. That it may have seemed like such a bizarre and unusual choice some years ago, but what we've learned from Oregon with all of the data that has emerged from Oregon and the data that's emerged from Washington is that this is a practice that can be done safely, it doesn't put patients at risk, it actually raises the floor for good end-of-life care for all patients because clinicians treat pain and symptoms more aggressively, they bother themselves to get education about how to do that more frequently, they refer to hospice more often, all that data tells us all of this. And so we think it's time for aid in dying to just be, like most medical practice, governed by best practices standard of care. So one of the places that really lends itself, and I wish I could say Colorado, because you probably care most about Colorado since you live here, that we're coming to do this in Colorado, but we're not. We're actually going to Hawaii. One, because who likes to go to Hawaii? I do. Okay, so Hawaii not only is a great place to visit, but Hawaii has this interesting statutory landscape that is very favorable to this argument. There's no prohibition. There's not even one of those old musty, dusty statutes that makes a crime of assisting a suicide, which some people worry means that makes a crime of aid in dying. We would say no, no, and I'll tell you about that in a minute. But it doesn't have one of those statutes. And it does have other statutes that are very supportive of patients being empowered with choices at the end of life. So we are going to Hawaii, and you can watch our website for our upcoming work on that. We'll be rolling that out in October. We're doing a big conference in October in Hawaii about this, and really inviting the medical community to appreciate and understand that they are already in an environment where they can provide that intervention subject to best practices, standard of care, and really encourage that to start to emerge. So that could do a number of things. I think when we start discussing that publicly, those who are opposed to aid in dying might, as Senator Hinkle did in Montana, rush into the legislature saying, no, no, we must prohibit this. So we are sensitive to that possibility, and we'll be working hard to make sure that if that legislation is introduced, that we're able to educate and encourage the citizens in Hawaii to oppose that. So that will be an interesting process to watch unfold. And we have a really interesting additional advocacy project where we are looking at the states, and there are a number of them, and I don't remember the number, but it's above 20 states. And I believe Colorado may fall in this category. A lot of states have an old musty dusty statute on their books that says anyone who assists another person to, quote, commit suicide is guilty of a crime. We don't believe that the choice of a dying patient for a peaceful death is any kind of suicide. And so we don't believe that those statutes reach the conduct of a physician providing aid in dying. And we are bringing a case forward to have a court consider and opine on that. So that case, also not happening in Colorado, but closer, that case we will be filing in New Mexico. And you can watch for that. That should be filed in the next several months. And then that will move, hopefully not like a glacier, through the New Mexico courts to the New Mexico Supreme Court, where that court will consider whether one of those statutes reaches the conduct of aid in dying. If the court finds that it doesn't reach that conduct, then that will be an environment where the practice can be governed by best practices, standard of care. Although, caveat, we would be watching obviously for a prohibition that is specific to aid in dying to be introduced into the legislature, and need to do the work to educate around defeating that bill. So that is another way of expanding choice. So I guess what I would say is we have a couple of really interesting, exciting ways to expand the end-of-life choices to include aid in dying. They're being brought forth in 2 test states, and if successful in those states, they have the potential to then be employed elsewhere, and I think really start to change the landscape in more states across the country, which I think obviously 70% of American citizens would like to see happen. So that is the update on really sort of the advocacy work that we're doing, and I hope that sounds really exciting and interesting and keeps you energized as members of our organization. And I would love to take questions or receive comments or suggestions from anyone.
With that person you're talking about who had the physician's order in place,
Yeah.
and it wasn't followed,
Right.
and she was intubated, once that happens, how difficult is it to have the intubation removed?
Okay, well, so that's a great question. And the good news... repeat the question. The question was, in the case that I mentioned where the patient was intubated against her wishes as reflected in a pulse, can I give you that? It's going to fall. The question was, how long did it take to get that corrected and get the intubation removed? The good news is that it happened very quickly thereafter. She was actually then transferred to a more intensive care hospital, and when she arrived there, the receiving physicians saw the pulse and said, this patient shouldn't have been intubated, and they removed it. So that's good. It should never have happened. So, you might say to yourself, well, why even bother, because it was just a short time. I mean, I'm sure we'll hear that if we file the case. The defense will be, no harm, no foul, because it was just a short amount of time. Don't bother us with a lawsuit. But our argument is, it might not have happened quickly. It might have imposed a lot of suffering.
Right.
And it's not right. So,
Why was she transferred? Do you want to ask?
because the hospital she was at wasn't the same level that could have dealt with her situation. I mean, the physician who intubated her obviously thought she was going to be receiving some aggressive care, not really understanding the point of the post, which is this wasn't a patient who was going to get aggressive care. Yeah.
You mentioned the shift in focus to standard of care as a strategy.
Right.
Is that the overall organization's trust, or is that the legal trust?
Repeat the question.
Yeah, the question was, moving to a strategy where aid and dying would be governed by standard of care, is that the overall thrust of compassion and choices, or just within the advocacy? I mean, we're a very integrated shop. I like to think that our advocacy work is very integrated with all of our work. And I think that in general, and I think you'll see some blog postings by our president, Barbara Coombs-Lee, about this shift in focus. I think we really kind of realize that this movement for end-of-life choice is maturing, and that the sort of old-style Oregon law, which, you may love it, you may hate it, it basically is a fairly rigid scheme that imposes a lot of burdens and obstacles on patients and burdens on physicians. So if you're familiar with the Oregon scheme, you know there's a lot of hurdles to qualify. And once you qualify, then there's a lot of paperwork to be completed, and witnessing, and multiple requests, and et cetera, et cetera. And at the end of all of that, even assuming you jump through all the hoops and you qualify and you get your prescription, and then the provider has a big reporting duty. Well, providers hate reporting duties. It's very burdensome to them. And so what we've learned is that while the Oregon model worked well and did a tremendous service, I think, to the whole country in being this laboratory where all that data that was collected and reported served this really valuable function. But now we have 13 years of data reported. And the data is very consistent year to year. And so we think we know that when aid in dying is made an available option, as I said earlier, it raises the floor for good care for all patients in the state, even those who just want aggressive pain and symptom management. It raises the floor. And for the relatively few number of patients who want aid in dying, it's safe. It doesn't put patients at risk. And a lot of study has been done. So I think we're at the point now where we can say, we don't need to impose that much burden in every state. I hope that answers.
Yeah. I guess my
Yeah.
comment was that there's a higher level of battle, which is human rights. Which is to say, there are people in this country, probably centered around the religious right, and there are alliance with various Tea Party people who would say, this is not a right. So and population is getting older. The technology is getting better to keep people alive, even if it means nothing.
Mm-hmm.
And the profit that comes out of the medical field is going up forever, especially for those procedures. So that, I kind of like what you said. I'm not disagreeing with it, but there is a higher level to fight on, which is this is a basic life, liberty, and pursuit of happiness. issue.
Right. That's a great point, and I'll just say it again. I mean, that animates our work at Compassion and Choices every day, which is we do believe that the choices that people are empowered to make at end of life is a basic civil rights issue, a human rights issue. So we advocate for, a broad array of choice and supporting patients in whatever their choice may be. So yes, we do that across the board, and we'll keep doing that for sure. Yeah.
Would you define healthcare provider?
Well, it really varies for what purpose you're talking about. So if you mean who can provide aid in dying, that's governed in Oregon and Washington by statute and in Montana by court decision, and that is a physician. So, I haven't seen anything that would suggest that aid in dying could be provided by someone other than a physician. Now, there are groups that advocate for a non-medical model, but that is not what Compassion and Choices advocates for. So, there's, for example, the group that calls itself Final Exit Network. FEN is its acronym. That's a group that thinks that friends and family should assist a dying patient in precipitating death. That group has been, as you probably know, investigated and prosecuted for federal crimes, and there's a lot of hazard around that. And we don't advocate for that at Compassion and Choices. So we're very focused on this being a discussion that can happen between the patient and the treating physician who knows the patient's medical condition and et cetera, and can provide a full range of advice about end-of-life care options.
I think the answer to Helen's question is somewhat obscured by what is known in the medical field as standing orders. And a physician can issue a standing order which governs the behavior of associated or allied health professionals, and they are permitted to do whatever the standing order says when they think it's necessary. Mm-hmm. So that means that nurses mm-hmm. or other personnel mm-hmm. can be involved.
Mm-hmm. Okay, great. Thanks for that. Yeah.
My question isn't completely clear to me, but I'm hoping you'll clarify.
I hope so.
This anyway. I'm trying to get. If you don't believe that a dying person choosing to end their life is suicide, is Compassionate Choices putting that out? Is this written about?
Yeah, like that's a great question.
Big question.
That's a great question. So I'll just say it again. The question was, what supports the notion that the choice of a dying patient for a peaceful death is no kind of suicide? I first became sensitive to that in looking at a report of the American Psychological Association. Any psychologists here? The American Psychological Association issued a report in 1997, I think, and I can, anyone interested can email me and I can send you their report, where they found that the choice of a dying patient for a peaceful death is fundamentally different from the choice for suicide. And there's a whole sort of array of things that they looked at. And so since that time, I have looked at the literature in the mental health field, and it's very consistent around that. There's a number of other studies that have spoken to that. And some of them come up in interesting contexts. There's a very recent one that looked at it in the context of patients who have had kidney dialysis who decide to stop, and whether the choice of that patient to decide to stop doing kidney dialysis should be deemed a suicide. And the conclusion is no. And so, it's really interesting to kind of track the literature and study in that domain, because there has been a significant amount of it. We actually have a policy proposal pending with the American Psychological Association right now, where the APA would adopt a policy that comes out and says that exactly, because their publications to date don't rise to the level of a policy statement, so we'd like them to adopt a policy statement to that effect. The thing that is kind of holding that, or to the extent that there is any difficulty in getting that moved into policy, is, as you may be aware, some faction of the disability community is opposed to the choice of aid in dying. They expressed the view that people with disabilities are so marginalized that somehow if aid in dying were available, all people with disabilities would be encouraged or forced to choose it. That is a non sequitur, and there's no evidence that anything like that has happened in Oregon or elsewhere, but they are a very vocal, aggressive advocacy group that slows down things like this policy that's pending with the APA. So that's where that is at. But if that can be surmounted, I think we'll see a nice policy coming out from the mental health professional community, really bringing attention to that distinction.
Okay.
Yeah.
I have another question connected. In terms of people collecting on insurance policies, I don't know if this is still accurate, but if someone suicided, their family members
Right.
can collect. What's
Right. So the question about if you choose aid in dying, does it adversely impact an insurance policy? And the answer is no in the states that have statutory enactments, because if you look at those statutes in Washington and Oregon, it carves that out. It says, the choice of a patient for aid in dying would not adversely impact the policy. And that's as it should be. And of course, the other thing, back to your question about what do we call this and why is this not suicide, if you look at the Oregon and Washington statutes, they come right out and they say nothing about this statute changes the fact that assisted suicide is still a crime in that state. So keep that in mind. Washington and Oregon are in that category of states that does make a crime of, quote, assisting a suicide. Now also, you may be thinking to yourself, well, what about those statutes and what do they apply to? And one of our little projects at my office is we do keep track of these other cases where the assisted suicide statutes are invoked in criminal proceedings as they should be. So for example, if you have two teenagers and one is distraught because his girlfriend dumped him and the other one says, hey, I have a gun, do you want me to hand it to you? And the first one says, yes, I want to kill myself. That is your classic situation. And there are actually, I don't know that I want to say a lot, but you see these cases from time to time around the country, and I think they are the classic situation that those statutes were meant to apply to. Someone with impaired decision making because they have some episode in their life that causes them to want to do themselves harm. So we kind of think of that as apples and oranges. The statutes have an appropriate application. It's not in the context of a patient dying of a terminal illness who wants a peaceful death. They're apples and oranges.
How good are we at deciding when a person is and is not terminal?
Well, that's a great question. How can we decide? How good is deciding or determining if someone is or is not terminal? It's something that is done all the time for various purposes. So, as you probably know, the hospice benefit under Medicare requires a diagnosis or a prognosis of 6 months or less life expectancy. So that, making that determination is done all the time by providers. The POST, this new tool around physicians' orders for life-sustaining treatment, the test for a physician on whether to suggest that a POST be adopted is the physician is supposed to ask him or herself, would I be surprised if my patient died in the next year? And if the answer is no, I wouldn't be surprised, they're to have that consultation and discussion about entering a POST. So for a variety of reasons, clinicians are engaged in the business of making this prognostication. There's actually a lot of studies that show that the life expectancy errs in the direction of opining that the patient has longer. So if there's error, it tends to be the physician saying, well, you have a year, but the patient really has 6 weeks. So to the extent that there's error, it's in that direction, not the other direction. And there are studies that document that. So I think, while, certain illnesses, it will be clearer than with others, I think clinicians are capable of doing that. I think it's also interesting to look at the Oregon data and now the Washington data because even though you are supposed to have 6 months or less life expectancy, you do see patients that get that diagnosis, who go through the process under the statute to get their prescription, and then they live longer than 6 months. Well, so what? It's not like if you get your prescription, you need to run out and fill it and take it today. And another really interesting thing about the data, very interesting, is that more than a third of the patients who go through that whole cumbersome process to get the to get the prescription, they don't go on to take it. They're comforted that they have it. That's a big deal. That turns out to be a big deal. Last year's data was closer to 40%. 40% of the patients got their prescription, felt comforted to have it, didn't go on to take it. They died of their underlying disease. Well, that's beautiful.
Prescription to
It's a prescription for life-ending medication.
palliative.
It's for aid and dying.
Oh, okay.
Yeah. So, it's not like I think what that reflects is no one rushes to this as you might expect. Yeah.
When I listen to the discussion, I love what you're saying, but there's an underlying tone of defensiveness. We're going to defend that a person might die within 6 months or a year. Well, hell, if we had these restrictions applied to our normal life,
Right.
we would have to get permission to go to downtown Denver because we have to prove this and prove
Right.
that. They're ridiculous.
Right. I mean, that is a great point. I do think
The point being-
I think his point is that in this advocacy work, one of our tasks is to not always be on the defensive, right?
Carrying off these.
Yes, I know. I do think that advocates in this field started off assuming, for example, that laws that make a crime of assisting a suicide applied to aid and dying. And we lived with that assumption for a long time. And I think we're just now sort of maturing to the point where we're saying, that's a crazy assumption. Why would anyone assume that? But it is a very widely held assumption and very widely held in the physician community. So that if you're in a state that has a statute that makes a crime of assisting suicide, physicians just assume that it applies. And it would potentially expose them to criminal prosecution for providing aid and dying. That is a very widely held assumption.
The corollary is that these prejudices go back a long way.
Yeah.
And they're embodied in law in people's minds. But if you spend most of your time anticipating the objections, you don't get out the core message, which is that people have a right to control their own life.
Yeah.
And
yeah, well, we certainly agree with that, and
I'm not
yeah,
saying
yeah,
it's a bad situation.
yeah.
But you don't. Anyway,
It's looking at it a different way, yeah.
The latest issue of Compassionate Choices magazine had an article by a religious person talking about how, physician-assisted dying is viewed in other faiths. And one of the apparently somewhat common themes is that many groups and people say, we do not have that right. We're given life by God. So you are now arguing against a very strong religious tenet.
Yeah, so what I think many years ago, the assumption was that the faith community or the religious community at large would oppose this choice. And I think that the early opposition from the Catholics primarily really fueled that, because you do see the Catholic Church and the Catholic bishops always opposing end-of-life choice, and it's not just aid and dying. They're opposed to removing life-prolonging interventions, including feeding tubes, and in fact, recent developments in the Catholic medical directives now require the continuation of tube feeding, whether the patient wants it or not. So that's something to be aware of. If you have your advance directive and it says, I don't want tube feeding, if you find yourself at a Catholic facility, it will not be honored. So that's something to be aware of. But one of the things that we started to really work on in, I would say, the last 10 years or so, is encouraging faith community leaders to come forward and speak in support of broad choice at the end of life. So now, typically, you will see if we have a legislative campaign or if we have a lawsuit, that we really invite the faith community that supports choice to come out. And we love them to come out with all their regalia. How many of you are faith community leaders? Anyone here with a beautiful thing like a collar or a hat with a cone? You know, we love the garb because it communicates such a message. So now very often we do invite these leaders in their regalia to speak out in support of choice, because there is a broad support in the faith community for patients being empowered with choice at the end of life. And that was secret, it was hidden, people didn't know about it, and it's part of our job to bring that out. And I think we're doing pretty well with it, actually. Yeah.
Your talk and all the comments are just, my mind is just sparking.
Yay!
A couple of things. Does Compassion Choices reach out to organizations, for example, Native American Rights Fund? I wonder, with the Native American spirituality, how that would support CNC. Thinking about when you go to Hawaii, the Polynesian base of religion prior to the missionaries. So it does seem like, and obviously Buddhism is so much about alleviating suffering. That's what the Buddha was saying. We're all suffering, and this is how you stop that. So I wonder how much of an outreach there is for that.
Yeah, well, we look for opportunities to reach out to all kinds of different demographics. Sometimes you run into conflicting themes. So, for example, you might think, well, Native Americans might be really supportive of this, or Alaskans with the Inuit Eskimo culture might be supportive of this because they have in their history some sort of interesting traditions about end of life. What you often run into, though, is that sometimes in those same demographic, there's also a very high rate of suicide, and I mean traditional suicide. And so it's a more difficult issue than you might think. But we are always looking for friends. I mean, we really, and you know, one of the things that we've done recently in our maturation as an organization is we now have a Washington, D.C. inside the Beltway office. That took us a long time to get there. We just have installed that office this year. The whole purpose and function of that office will be to be making friends among that collection of trade associations and groups that cluster in the nation's capital to have their issues heard. So I think that's another reflection of the maturation of our organization and our movement, and I think, even though I'm grateful not to be that person will be opening new doors for us. And, you know, visiting places like the AARP, where, of course, you know, we should be an issue that is embraced at AARP, and yet we have been held very much at arm's length for a very long time. So we now, with that office, have a new capacity to build those bridges, open those doors, and we'll be doing that. So.
Another thought, what is CNC doing as far as reforming Medicare? Is CNC working?
Well, we have we have one fun project that I didn't mention that I'd be happy to mention because I love this project. But it's a very narrow part of what might be done vis-a-vis those federal entitlement programs. We don't do much with the entitlement programs, but one of the things that came to our attention is that providers who impose unwanted care then turn around and bill the federal entitlement programs. So say you're a person who doesn't want a feeding tube or a ventilator, and you've done your advance directive and you've got your post, and yet you're imposed with care that you didn't want. Then your provider turns around and gets reimbursed. That's so wrong. So we took a look at that, and we looked at the very complicated Medicare, Medicaid statutory and regulatory framework, which is a hideous project, and we found out that reimbursement for unwanted care is prohibited. Beautiful. That's a beautiful thing, right? We don't need to change the law. We don't need to enact a new regulation. We just need to bring the issue into the public eye. So we approached the group that is the watchdog of Medicare and Medicaid funding, which is called the Senior Medicare Medicaid Fraud Patrol. Maybe you know about them. They're active in all 50 states. They're funded by the federal government. And we went to them and we said, hey, listen, we've noticed that it's not permissible to do this reimbursement, and yet it happens. And they thought about it. It took them 6 months. They called us back like just last week, and they said, you know what, you're right. That's not right. So we are going to print your article in our newsletter, and we're going to educate around this at our next conference. So that's great. And that's important. And people should have that in their mind, which is, if there's unwanted care, or if you think you see unwanted care coming your way, one way to defend against it is to say, this is not reimbursable. Well, guess what? Then they'll suddenly say, well, we're not going to give you that care because we won't be reimbursed. So that's kind of a fun project in that domain.
I have one quick question and then another one. So your indication about the small hospital that he didn't give the right, he didn't interpret this correctly. Does that mean that at the end of my life, I got to be sure that I'm in a big city and that I go to a big hospital, or
well,
was
hopefully
that just
not.
an individual problem with that doctor interpreting that thing?
Right.
Because
Yes. I mean, hopefully, the utility of our bringing the case and raising the discussion is that it will do a lot of education in the provider community
Right.
that they need to be attentive to patient wishes. So it is an ongoing professional and consumer education project.
Yeah. But if you're in a rural community,
It doesn't necessarily mean if it's rural, it just could be that this provider wasn't sensitive, and we're going to try to sensitize the entire profession to the duty to respect patient wishes. Yeah.
On the subject of reimbursement for government programs, where are we with the death panels?
Right. Well, you know, I had a couple slides, and I talked a bit about how important it is that patients get comprehensive counseling. We know that's important. So, as you know, in the omnibus healthcare reform, there was a provision that was going to provide reimbursement for end-of-life counseling. We thought that was great because when providers know there'll be reimbursement, they're more likely to do the service. That was an important thing, but it did lead to that crazy debacle about the death panels, and it was pulled out. So we're now, you know, in the need to go back to the drawing board to have a new piece of federal legislation that will ensure that there is reimbursement for comprehensive counseling. I think that the whole death panel debacle, it did promote a backlash from mainstream medicine, where pretty much all of mainstream medical community stood up and said, that's crazy, these conversations are important. So it didn't need to be sort of a fringe advocacy group like Compassion and Choices to say how important it is. You've got everyone in medicine saying this is critically important. I think we will see some progress, but you know, the federal legislative process is slow. So I do think at the same time it's great for states to go about the business of adopting comprehensive counseling provisions like we have seen done in California and New York, and perhaps we'll see done in that model law, and that the states can take on some of that until the federal government, you know, does what it should do.
So California and New York equal about 40% of the
population. Yeah. So a lot of patients, you know, hopefully are beneficiaries of that.
Speaking of California and New York, how well are those laws working? Do we have any feedback on that?
Yeah, that's a great question. Do we know if once the laws are passed, does anyone know about them, and are they working? Well, this, you know, the sad thing I think in California is that the Hargett case, which I mentioned, where the woman wasn't told about palliative sedation, that care was delivered after enactment of the Right to Know Act. So, you know, you'd like to think, well, if that statutory enactment happened, surely the provider would realize, and the patient and the family were pretty savvy about asking, can't anything more be done? You know, most people aren't going to know to say, I want palliative sedation. And by the way, if you say that, it may raise some huge red flag anyway. There's probably a pretty delicate way to have that conversation so the provider doesn't run and hide. But even though the family was saying, can't something more be done, which should have been the trigger to say, well, this is the range of options, she never got the kind of counseling that was comprehensive, and she was never told about palliative sedation. So the utility of bringing that lawsuit forward is to bring attention to the duty under the statute. So, you know, of course, the statute will be part of the argument in that case.
Who's the lawsuit against?
It's against the provider. It's against the hospice. I mean, she was in hospice care. She was enrolled with VITAS. Has anyone heard of VITAS? Are they active here? It's the nation's largest for-profit hospice chain, the largest one in the country. And they should have educated their staff about this intervention. You know, it's really inexcusable. Yeah.
What worries me what you say about Catholic hospitals. If you're with Kaiser, and I believe Good Sam is a Catholic hospital now, is the only way that you protect yourself by getting to hospice care?
It could be. It is for people. Oh, repeat the question. How concerned should consumers be about their provider being Catholic if they're worried about their wishes being respected? I think you do need to be concerned. And it's hard, especially in rural areas, if there's only one hospital or one provider, and that happens to be Catholic, and your wishes aren't wishes that the Catholic teachings would respect. That is very troubling. You want to think about that early so you can look for a provider that will be respectful of your wishes. Because if you wait until there's a crisis and you find yourself in a Catholic entity, then it's very difficult to have your wishes respected. We do a lot of work in this area around, particularly, and it's been active in Colorado, as you know, when there'll be a merger, or a consolidation, which is very trendy these days, that healthcare providers merge. And one of the merger partners is Catholic and the other is not. And following the merger, suddenly both entities follow the Catholic directives.